So I turn now to the applicant side and give you the floor. Please, the floor is yours.
Dear President, dear distinguished judges of the Grand Chamber, my name is Johan Heymans'ın, and I appear before you today together with my colleague, Professor Johan van der Lanotte, to speak for Mr. Yasak. Today, we come here in sorrow. In 2023, we stood in this court in the Yalçınkaya case, and we left with hope. Hope that the powerful judgment that your court rendered would restore the rule of law in Turkey and protect the rights of those persecuted without cause. But we were wrong. Turkey did not comply with your court's judgment. On the contrary, the Second Chamber's judgment in this Yasak case is now used by the Turkish courts to justify the same violations your court already condemned in the Yalçınkaya case. And that is why this case is so critical. And that is why so much is at stake. Until now, 150,000 people, teachers, nurses, students, ordinary citizens, were convicted for membership of a terrorist organization. And last year, even 14-year-old girls were put on trial for the same reason. And all these victims have placed their hopes in your court to put an end to this dangerous tendency, a tendency that goes beyond Turkey. As the United Nations Special Rapporteur Ben Saul in his third-party submissions explained, anti-terrorism laws are used, or better abused, to silence dissenting opinions. This results in terrorism no longer being defined by a violent or criminal intent, but by association. And the mere fact that one has some kind of connection to an organization which arbitrarily and a posteriori is qualified to be a terrorist organization automatically results in them being convicted for terrorism. And that is unacceptable. And that is what we will demonstrate to your court today and what is explained in our submissions. As to our pleadings, my colleague will first focus on the factual aspect of foreseeability under the Article 7 of your convention and thus address the questions 2, 3 and 4, the first part of the questions your court asked. And then I will return to address the legal aspect of foreseeability and thus the questions 4, the second part, 5 and 6. Due to the time constraints and similar to the government, we refer to our written submissions regarding question 1 and the violations under Article 3 of the Convention. However, first an important preliminary remark on the Second Chamber's decision of your court. To us it is clear that the Second Chamber was misled, factually speaking, by the documents presented to them, and which led to an unjust legal conclusion. As demonstrated in our Annex 3, at least 6 paragraphs in the Second Chamber's judgment misrepresent either the indictment or the decision of the domestic courts. Terms such as clandestine, secret, recruiting, which was also cited by the government a moment ago, appear in the Second Chamber's decision, while these words are nowhere to be found in the actual indictment or the decisions of the domestic court. Even more troubling is the fact that documents which were never part of the original case file continue to be added to this file by the government. It happened both before the Second Chamber and now also before your court. And for instance, we are now confronted with a new report of the HTS about the phone contacts and new witness statements which were not even part of the original case file and of which the domestic courts were not even aware when taking their decisions. Likewise, important factual points are not correctly presented in the government's submissions. We note, for instance, that the citations of Mr. Güllen, which should allegedly indicate or prove his intent to incite people to commit violence or terrorism, date in reality from before 2000 and were already part of the trial which was held against Mr. Gülen in 2008, and in which he was acquitted of any wrongdoing by the Turkish courts. Similarly, the government continues to refer to, for instance, the witness statement of BA, which would be, according to them, a crucial witness statement, while that was not one of the conclusive points of evidence which was taken into account by the domestic courts to come to a violation or to come to a conviction. We therefore urge the Grand Chamber to exclusively focus on the facts and the original documents as used by the domestic courts, and not rely on the government's post hoc reinterpretations of original documents, and not rely on the additional documents that were never tested at trial, but which are now joined to this case file. I will now pass the floor to my colleague. Dear President, distinguished judges of the Grand Chamber, I will now turn to the lack of legal foreseeability of the crimes Mr. Yasak was convicted for. Under question 4, your court asked whether the interpretation and the application of Article 314 of the Turkish Criminal Code, which defines what is an armed terrorist organization in Turkey, evolved in a foreseeable manner. And the answer is clearly no. Until 2016, Turkish courts consistently held that violence, or at least a clear intent to use violence, was a core element of terrorist membership. And that principle was in line with international standards. But after 2016, that radically changed. Suddenly, it became sufficient for an individual to be merely associated with the Gülen movement, regardless of whether they had engaged or even supported any violent or criminal acts. Furthermore, since 2017, the Turkish Court of Cassation introduced a whole lot of new legal concepts. So we have heard a lot of references to old jurisprudence, but a lot of new concepts were introduced in 2017, new legal fictions, which furthered this legal uncertainty. It labeled the Gülen movement as a sui generis terrorist organization. The defining features of terrorism, violence, and weapons were discarded. Instead, mere membership of a lawful organization, or even the fact that you had some kind of proximity to a person that was alleged to be part of the Gülen movement, was suddenly sufficient to be convicted for terrorism. The layered hierarchical structure doctrine, which was introduced in 2017, exemplifies this shift. These 7 so-called layers of hierarchy, they were created out of whole cloth by the judiciary. They do not provide any objective criteria to determine in which layer you would belong. There is no meaningful defense, consequently, that could be held against such classification. And these layers transformed what were once legal activities, teaching, studying, or even tutoring, into retroactive indicators of terrorism. And that's what happened to Mr. Yasak. He was convicted for tutoring students. There is no evidence that these students were involved in any violence or of any crime, or even worse, in the alleged coup. And neither was it ever examined by the Turkish authorities, which would have been crucial. More importantly, is that the Turkish courts have forgotten, or seem to have forgotten, about the basic principles of criminal law, notably that crimes should be individualized. A teacher, a doctor, a student, they all could suddenly be held criminally liable because someone, somewhere in the Gülen movement, would have been part of the army and would have consequently had access to weapons. That's the position that the government takes, and that leads to collective guilt, which replaces individual criminal responsibility. And that is unacceptable in light of foreseeability. Similarly and crucially, the domestic courts no longer inquired into the intent of the accused. And it is clearly demonstrated by the Annex 1, which the government submits to your court. It lists all the acts which would be indicative of the alleged terrorist activities of Mr. Yasak, but it says nothing about the mental element, about his state of mind. While when one looks at the testimonies in the case, all the witnesses say that they were completely unaware of the fact that the Gülen movement would have had any terrorist objective or aim. And the same is true for Mr. Yasak. He was completely unaware if that would have even been the case. So intent is merely presumed, and this leads, as your court already stated in the Yasin Kaya case, to an almost automatic presumption of guilt. The government wants to stress the difference with the Yasin Kaya case by stating that it concerns different facts and that now they rely on more factual elements. But in reality, it concerns, in its essence, the same problem. In both cases, the domestic courts did not investigate the intent. They did not individually and specifically examine the mental element. And that's the problem. What we are witnessing is a fundamental breakdown of legality. The mental element, dolus directus, under Turkish law, requires proof that the accused knew of the group's objectives, violent aims, and deliberately sought to further them. But since 2017, this has been replaced by a presumption. Once you had a certain level of education or a certain hierarchical position, one should have known that the organization was a terrorist organization. There is no assessment of an individual's knowledge, no inquiry into their will. The burden of proof is inverted, guilt is assumed. Even more troubling is the retroactive criminalization. Lawful conduct, opening a bank account, tutoring students, working for the Quorum Educational Services, which was a legally established and inspected organization, was suddenly reinterpreted after the fact as being criminal. And even in the Sajmas decision, the Turkish Constitutional Court concluded to a violation of legal foreseeability. The Turkish jurisprudence has not evolved in its essence, because both the Constitutional Court and the Court of Cassation in Turkey continue to accept that people are convicted for being a member of a terrorist organization without individually inquiring into the intent, into the mindset of the accused. Dear President, dear distinguished judges of the Grand Chamber, foreseeability is the cornerstone of legal certainty. But when definitions are invented ex post facto, when guilt is presumed, when there is no inquiry into the mental elements, and when lawful behavior is criminalized retroactively, the law becomes arbitrary. And that is exactly what happened with Article 314 of the Turkish Criminal Code, as applied specifically with regards to the Gülen movement. This is not justice, it is not law, and it is certainly not foreseeable. And we therefore, and in line with our submissions, respectfully request your court to come to a conclusion that there is a violation of Articles 3 and 7 of the Convention. We request your court to come to a firm decision in which these violations are condemned, but more importantly, in which clarity is brought, clarity to make sure that the Turkish judiciary can move towards a clear and foreseeable legal framework. And that is missing at this moment. And Mr. Yasak's case is a very clear example of that situation. We thank you.
Thank you for your submissions.